Welcome to week 2 of our spring semester of evidence, where we are continuing our discussion of impeachment. We're covering the cases from your casebook on pages 525 to 562. The first case we covered was State v. Broadnax. This is a Supreme Court of South Carolina case from 2015. As background, this case had a masked gunman that had robbed a chicken joint. Shortly after, the defendant was arrested. He closely resembled the description given by several observers of the gunman. At trial, the defendant testified in his own defense, and the judge allowed impeachment by several prior convictions, including 3 convictions for armed robbery. At issue was whether those prior armed robbery convictions should have been admitted, and is theft or armed robbery a crime of dishonesty? This court held with the concurring justices that felt that yes, stealing was a dishonest act. However, the majority for this court held that stealing is not the same as lying, so they felt that it was not the same as a dishonest act. Because the court held that the prior convictions were not crimes of dishonesty, they could only be admitted if they satisfied a balancing test. However, the court held that admitting these convictions was harmless error because the proof against the defendant was so overwhelming. Next, we'll have hypos from your casebook, numbers 1 through 3, on pages 530. The next case we covered was Luce v. United States. This is a Supreme Court of the United States case from 1984. As background, the defendant in a drug case moved for a ruling to preclude the government from using a prior drug conviction as impeachment evidence if the defendant testified. The trial court denied this motions in limine, finding that the evidence was admissible under FRE 609A. The defendant did not end up testifying because of that ruling. He was then convicted and appealed, claiming that the district court abused its discretion in refusing to find that the prior conviction's probative value was substantially outweighed by its prejudicial effect under FRE 609-1. At issue was whether that district court should have excluded the defendant's prior convictions for being substantially prejudicial. In an 8-0 decision, the Supreme Court held that no. The defendant must have testified to preserve that claim of improper impeachment. So in this case, because the defendant lost that motions in limine, he did not testify, and so the Supreme Court held that he lost the ability to claim improper impeachment because he never testified at his trial. The court felt it was impossible to decide whether the probative value outweighs the prejudicial effect without knowing the nature and the scope of the defendant's testimony. Our next case is Davis v. Alaska. This is another Supreme Court of the United States case from 1944. As background, Richard Green testified for the prosecution and identified the defendant as one of the men he saw near his home trying to open a stolen safe. At trial, the defendant wanted to prove that Green was on probation as a juvenile delinquent for burglary. The defendant wanted to show that Green may have feared he would have come under suspicion for theft, and so Green had an interest in identifying someone else as the perpetrator. State law had barred this type of evidence to protect juveniles. At issue was, did the state court err in not allowing the defendant to present evidence of Green's prior theft? The Supreme Court reversed in a 7-2 ruling, holding that yes, the defendant's interest in showing the potential bias outweighed the state's interest in protecting the anonymity of a juvenile defender. Our next case is United States v. Abel. This is another Supreme Court of the United States case from 1944. In this case, the defendant was on trial for bank robbery. 2 of his accomplices had already pled guilty, and the plaintiff introduced testimony of one of his accomplices, L., who implicated the defendant in the crime. The defendant countered with testimony of a prison acquaintance, Mills, of both the defendant and L, who stated that L had told him he was going to testify falsely to implicate the defendant in order to receive favorable treatment from the government. The trial court allowed plaintiff to put L on the stand to testify that Mills and the defendant were members of a prison gang whose motto was to lie, cheat, steal, and kill to protect each other. The implication was that Mills had held a bias in favor of the defendant. The Court of Appeals reversed, holding that even though L's testimony was admissible as extrinsic evidence to show bias, the plaintiff was improperly allowed to infer that because Mills was a member of the gang, he must be lying. FRE 608B says that the plaintiff can impeach on cross-exam to show a witness's character for truthfulness, but cannot use extrinsic evidence like L's testimony about the gang. At issue was whether or not the trial court abused its discretion in admitting L's testimony. The Supreme Court reversed the Court of Appeals decision, holding that it was within the trial court's discretion to admit the extrinsic evidence of L's testimony because it was sufficiently probative on the issue of Mills' possible bias towards the defendant. The court held that the trial court was also within its discretion in allowing in the evidence under FRE 403, finding that the probative value outweighed the prejudicial potential. Next, we have more casebook hypos, numbers 1 through 3, on page 541. Our next case is Shelkson VA. This is a Supreme Court of Nevada case from 2009. As background, this was a wrongful death action against an anesthesiologist who allegedly had failed to give a test dose to the decedent, a woman in labor, before administering an epidural. The plaintiff, the widower, presented testimony of Nurse Clark, who was on duty during the epidural. The testimony was mainly favorable to the plaintiff, saying that the defendant didn't appear to administer a test dose. But she also testified that because of her positioning, she couldn't see the defendant administer the epidural. The plaintiff sought to impeach Nurse Clark by presenting testimony of another nurse who testified to a comment Nurse Clark had made to the defendant. That defendant administered a big dose of the drug, and then the victim seized immediately. The trial court didn't allow this impeachment, and the jury found for the defendant. At issue was whether the trial court erred in barring that impeachment evidence of Nurse Clark's alleged prior statements. This court reversed. However, there was a detailed dissent that argued that the trial court did not abuse its discretion in holding that Nurse Clark's prior statement was not actually inconsistent. The majority here, however, felt that there was an inconsistency because Clark didn't remember her prior statements to the other nurse, and that failure to remember was a denial. Our next case is United States v. Mack. This is a United States District Court case from the District of Connecticut from 2016. As background, the defendant was convicted of several crimes, including conspiracy to murder Ian Francis, and then conspiracy to murder Charles Jernigan, who would testify about the murder. A co-conspirator, Lucian, testified against the defendant. The plaintiff offered evidence that, while confined, Lucian had told a cellmate, who was wearing a recording device and working with the government, that the defendant wanted Jernigan gone. The defendant contended that that prior statement could not be admitted for rehabilitation because since Francis's murder, Lucian had had an incentive to blame the defendant. Was Lucian's prior statement properly admitted for rehabilitation at trial? This court held that the prior ruling was correct. The court analyzed FRE 801 D1B, part of the rules on hearsay, which discussed when a prior statement can be admitted substantively and not just for rehabilitation. The court held that at the time Lucian spoke to his cellmate, he was facing much less prison time than he did later. So maybe the statement was made after there was a motive to lie, but that motive was not yet at its full strength. We have Casebook Hypos 1 through 5 on page 554. Our last case is United States v. Lindstrom. This is a United States Court of Appeals case from the 11th Circuit from 1983. As background, the defendants owned a company named Bay Therapy. They were charged with a scheme of inflating medical costs and defrauding insurance companies. The government's key witness was an employee of Bay Therapy who testified that the defendants altered records and billed for treatments patients didn't receive. The witness had long-standing mental health problems. The defendant had evidence that the witness was hospitalized for a suicide attempt, that she had offered a patient $3,000 to murder the wife of an ex-lover, that she was involuntarily committed after a drug overdose, and that she had schizophrenic reaction and saw authority as something to be manipulated. The trial court did not allow the defendant to cross-examine the witness about the murder contract, her attempt to shoot an ex-lover, and that she told hospital staff she attempted suicide to manipulate her boyfriend. At issue is whether the trial court erred in not allowing the defendant to cross-examine the witness on these issues. The court held that yes, this was an abuse of discretion on the part of the trial judge to not allow the cross-examination. The court found it was reversible error for violating the defendant's confrontation clause rights.